Why is it that some nations approach legal matters in such different ways? What can be learned from these differences and how can they be applied to reform and improve our own legal systems? Today, we delve into the fascinating world of comparative legal research, a method that unlocks the answers to these questions and more. Comparative legal research is a journey, a systematic exploration of legal systems, doctrines, and practices across various jurisdictions. Unlike its counterpart, doctrinal legal research, which focuses solely on the laws of a single jurisdiction, comparative legal research takes a wider, more encompassing view. It actively seeks out the similarities, differences, and patterns in legal norms, institutions, and processes across diverse legal traditions, cultures, and contexts. This journey begins with the selection of jurisdictions. Researchers choose the areas they wish to compare, decisions often guided by the research objectives and the scope of the inquiry. They might opt for jurisdictions with similar legal traditions to identify commonalities and variations, or they may go for jurisdictions with contrasting legal systems to investigate divergences and cross-cultural influences. Next comes the identification of legal issues. Researchers pinpoint the legal issues, concepts, or doctrines they wish to compare across jurisdictions. They focus on specific areas of law, such as constitutional law, human rights, or environmental law, and examine how legal norms and practices may vary or converge across different legal systems. Then, researchers apply comparative methodologies. They may employ various methodological approaches, such as functionalism, formalism, or contextualism, to compare legal systems and interpret comparative findings. These methodologies can range from qualitative methods like case studies or textual analysis to quantitative methods, such as statistical analysis. There are, however, certain methodological considerations to be taken into account. Cultural and linguistic factors, for example, can greatly impact legal concepts, terminology, and interpretations. Therefore, the accurate and sensitive translation of legal texts and concepts is crucial. Moreover, a nuanced understanding of the socio-political, historical, and cultural contexts in which legal systems operate is required. Researchers must interpret legal norms and practices within broader social, economic, and institutional frameworks to ensure the accuracy of their findings. Finally, the phenomenon of legal transplants and borrowing, where legal norms and practices are transferred or adapted from one jurisdiction to another, is examined. Researchers analyze the processes and implications of legal diffusion, assessing the impact of foreign legal influences on domestic legal systems and practices. In conclusion, comparative legal research is a multifaceted process that provides invaluable insights into the diverse world of law. It involves the careful selection of jurisdictions, identification of legal issues, application of methodologies, and consideration of various cultural, linguistic, and contextual factors. Through this process, researchers can uncover patterns, variations, and cross-cultural influences that enrich our understanding of law and society, fostering legal innovation, policy reform, and global dialogue.